Ma'am, we are live on YouTube also, ma'am, right now.
Okay. Live on what?
YouTube, ma'am.
YouTube. Okay. Okay.
Ji, ma'am.
Okay. So should I share my screen first?
Just give us, ma'am, 2 minutes. Just give us 2 minutes.
Okay. Okay. No problem. No problem. So I don't think I can speak for 1.5 hours. It's too much time for me to talk about patents. I am not the expert of patent, but anyway, I'll share my experience.
Ji, ma'am. Good afternoon, everyone. See, what is it? Sir, what is it?
Yes.
सर आपका वीडियो ऑफ है सर.
हाँ, वीडियो नहीं है.
अच्छा सर, ठीक है. Shall we start, sir?
Yes.
Good afternoon, everyone. I welcome to all the participants, all the listeners for this lecture series on intellectual property rights. So, for to invite Dr. Arvind Tripathi, sir. He is Professor and Head, Department of Orthodontics, Crown and Bridge, and Dean, PG Studies and Research, to kindly introduce our speaker. Sir, over to you, sir.
Good morning, everybody. Thank you, Vivek. And it's indeed a pleasure to lead from the front to initiate the program by introducing to the audience the distinguished presenter of today. It's rather unfortunate on my part that I have not known her personally because our paths have been different. But from what I gather, she's a distinguished alumnus from All India Institute of Medical Sciences, New Delhi, having done her PhD in nuclear medicine. And she has been a member of several scientific committees like American Association of Cancer Research, National Academy of Medical Sciences, New Delhi, Indian College of Nuclear Medicine, Society for Nuclear Medicine India, Society for Biological Chemists, Indian Association of Biomedical Scientists, and World Association of Radiopharmaceutical and Molecular Therapy. She's also a member of the editorial board of the Indian Journal of Nuclear Medicine and has more than 200 publications and 9 patents. Dr. Jaya Shukla currently serves as additional professor in the Department of Nuclear Medicine and positron emission tomography at PGI Chandigarh. And it's indeed a privilege for all of us here in Saraswati Dental College to have us amongst us online for this add-on program on intellectual property rights. Intellectual property rights is something which is ill understood by all researchers. We are so enthusiastic about contributing original work that we instantly are saddened when our work is taken away by somebody else, or our work is plagiarized, or we are not included in the list of authors where we should have been mentioned as a contributor. Over a period of time, gradually, the different agencies that oversee the publication of original research have started becoming more and more strict. They now inquire about the role of individual contributors. Despite that, people are paying money to get their name included in different portals of research contribution, which is highly derogatory to the entire idea of doing original research and doing hard work and doing original thinking and contributing to science. Plagiarism, taking away somebody else's work and putting your name on it, or adding on your name to a research which doesn't really concern you, is only short-sightedness on the part of ardent desire to enhance your profile without actually working hard at it. So from the point of view of the researcher, what are intellectual property rights and what do we do to guard them probably is the discussion for today. And without much ado, I would now request Dr. Shukla to make her presentation.
Thank you, sir, for your kind introduction. First of all, I thank IRDC, Saraswati Dental College, for inviting me. Though I'm not the expert in this field, but I have filed and I have been granted few patents. So maybe I can better suggest what researchers should do to patent their rights, intellectual property right. So it's not moving. Okay. So I'll talk about in these lines, the short introduction of copyright, trademark, and patents. Its steps for filing a patent till getting the grant, and what are the patent rights, how to transfer your technology, and about my experience, my own experience. So first of all, I would like to say that this property, intellectual property, it is not made up of brick and concrete, but it is generated from our intellect. So it is called intellectual property. And same as as we own our house, similarly, we own this, we can rent it, we can share with, we can sell it, whatever we can do with our brick property, we can also do with our intellect property. So intellectual property right has three parts, that is copyright, trademark, and patent. All these are covered in intellectual property rights. So copyright is just like copying the rights. Like if we want to, generate more copies of our thing, just like it is like that we, whenever we publish some paper, we sign a copyright. So if we publish in a journal, so whatever we have written, it's in their custody and they have right to multiply, to copy, to transfer, to share with everyone. But we, even if we have published some paper, we cannot publish whatever we, or we cannot share with anybody whatever we have published in that journal. So we have to take prior permission from that journal to share with others, and even we cannot share our full paper without in public domain. We can share it for academic purpose, we can share it with our friends, with our colleagues, but we cannot publish in the public domain if it is, because it is now the property of that journal. Or similar with the book also, drawing, paintings, even if we want to copyright our presentation, like I'm giving this presentation, I can, it is my copyright. So if it is published, nobody can copy it for commercial purpose. This is also be noted. And trademark is a brand name like Bata, Nike, and we are getting, and the companies like Glaxo, or the Sun Pharma, these they have their own trademarks, and this is the brand value. So we always recommend that you don't buy local medicines. Just if for some things we prefer good brand name. So it is basically it is the goodwill of a company which is branded. A company take these trademark, and these are then used as their which distinguish their goods or the services from those of your competitors. Like some medicines are good for so some from pharma, Sun Pharma. My husband was given a medicine, and the doctor said, buy Sun Pharma. Don't buy any other, buy from Sun Pharma only. So this is their goodwill and their identity. So these trademark, it is TM and circle TM, it is represented. When we apply, it is TM and circle TM. When it is all granted, then it is R. It is denoted as R and circled R. So the validity for this trademark is 10 years, but we can renew it for after every 10 years. And now coming to patents. Patents is, it is the novel work you are doing. It is innovation you are doing, or it is I think any innovation you can be, which is different and which is done. It's not that done, but if the similar thing is already available in the market, you are audible. May I know, am I audible or not?
Yes, ma'am, you are audible, ma'am.
Okay. So, okay. So the thing is that we can do whatever we are doing. We are researchers, so we are doing some good things. And if we are adding to the existing technology, then also it is novel. Like if we are making some cost effective things, then this is also novel. So you can patent your things. So I'm giving some example, like it is a book, which is, and if you are writing some chapter in a book, that is also copyrighted, but copyright are with the publishers. And similarly that you can recognize PGI with this logo and with Saraswati Dental College with this logo. So these are also patented. Nobody else can take these logo to denote their company or their hospital or their institute. So these are similarly, this is logo and the example of logo and copyright. So coming to how you file the patent, how you publish it, and then how it is granted. So once you get an idea, you for some research. So don't jump into patenting, just conceptualize your idea, and then you see whether it is feasible. You can do it. It is doable. It has some contribution to the society or to the, and not it's not necessarily the society. Even if it is good for academics also, then also you can patent it. But you can think of filing it. You file it in two ways. If you have redone the whole research, like if somebody has done the research and he or she knows that this is novel and it is useful and it is marketable, it can be commercialized, then go for filing the patent. Patent can be filed in two ways. Like once you have done some research and you know that it can be scaled up, or it will be good for us, and then you can do provisional specification, because it is very important to file as soon as possible. Don't jump into it, but it is also important to first file it. So it is provisional specification is, you know, your innovation, you have done some basic research, then you can file provisional specification. Or if you have already done all the research on your idea, so you can even file complete specification. But one thing you have to keep in mind, if you are filing provisional application, then it should be completed within a year. If you are unable to file complete specification within a year, then it will be abandoned. You have to refile, and you will get, maybe in during that period somebody else get that idea, and he or she can patent that. So it is very important, when you see if it is doable within a year, then only you file it. Otherwise, your whole exercise will be lost. So either you file provisional, or if you have done all the research and now you are, then you can file complete specification. So for provisional, if you are filing today provisional application, so within 12 hours, you have to file complete specification. Or if you have done, you have all the data with you, you can file complete specification, no need to file provisional. So provisional is not mandatory. You can directly file complete specification, but you should have complete data, complete information. So once you have filed complete specification, then you can file early publication. Publication is then your your patent, whatever you have written, it will be in public domain. So it is because people can see it, and if they have any objection, they can write it to the patent attorney, patent office. So it is otherwise, if you are not if you do not file early publication, it will be published within 18 months of your filing complete specification. Once you have filed either provisional or complete, the date will be date of first filing, either provisional or complete. That date is very important. Everything will go on that date. You will be assigned a patent number, filing number. So after 18 months of filing your complete or provisional, this your idea will be published, and after that, and within 48 months, that means 4 of filing complete or provisional, it will be, you have to file request for examination. If you are not filing that request for examination, there is a form 18, you have to fill it, you have to deposit the fee, then only it will be examined. So this and that the filing date is called date of priority. So from that day, from the date of priority, and within 18 months it will be published, and within 4 years it will be examined. Once it is you file the form 18 for request for examination, it will be examined by your application will be assigned to a controller who will review it, who will examine it for the patentability and whether it for patentability and other requirements for patent. So the attorney, he or she will examine your patent, the application, whatever you have written, whether it is not copied, whether it is whether it is unique, novel, or it can be commercialized. So all these issues will be taken care of, will be checked, reviewed, and then you will get first examination report, that is FER. On that FER, you have to answer those queries, whether if the controller think that it is not patentable, so you have to justify yourself. It's not that he or she said it is not patentable, so you keep quiet and think that my idea is not good, it is not patentable, it cannot be commercialized. So don't think like that, because all the controller, they are not expert in your area. So you have to give justification, clarification. This is not what you have said, or what. They will also give you some publications, some papers, to see whether from where they get this idea that it is not patentable. So you go through those papers which have been given with FER. You have to read it, and you have to see whether the same innovation, same idea was there or not. So you can now justify that, you can reply and justify that this idea is not the same which is already published. It is how different, in what way it is different. You can give the detailed information to the controller. Then if he or she is satisfied with your answer, then they will call you for hearing. You can give hearing by yourself, or with the help of some attorney or the patent agent. So whatever you feel like you can do, you can take help of in writing provisional specification from attorney, from patent agent, and you can also help, because they are expert. You can write your application, but give some idea from them also. And it is always good to take expert advice, but you should be there to see all the time, because the patent agent or the attorney is not expert in your field. So he or she may make some mistakes. So give your idea, or give in a written format, just like you write a paper. You give it to your agent or the attorney, and be in touch with him or her, so that there is no mistake and communication gap. So what you want to convey to people, it should be conveyed in the same way, right? So it is always good to take help of attorney or the agent, and then you are called for for you that way. How to write in complete specification, you have to write what you want to patent. It is called what? It is called, I just forgot. Then I'll tell you later. So once you clarified the queries raised from the controller, and if he or she is satisfied, they'll call you for hearing. You have to present, either earlier it was you can present physically, but I have always presented by online mode. And so you can be there during hearing, and with your agent or the attorney, but you have to be there, because attorney may not be able to clarify all the queries which are raised by the controller. So it is, don't give the whole soul right to the attorney, because again I am repeating that he or she is not the expert in your area. So you know better what you have done, why you have done. So you have to clarify that it is not that attorney or the controller is saying. You always clarify. You whatever objection they are raising, you have to clarify them. So once it is met, once the hearing is done, your controller is satisfied, then the patent will be granted. And there is always, in every step there is a timeline. For FER, you have 6 months to reply to controllers your first examination report. You have 6 months, and if for any reason you are not able to do it, then you can ask for extension of further 6 months. So you have 12 months in hand to clarify the first examination report, to reply your first examination report. And after that, hearing will be done and patent will be granted. Okay, you can also file expedite application. In some cases, earlier if you want, okay, one more very important thing is, this is for Indian patent. If you want to patent your idea internationally, then you have to file PCT. And for that, it is said that earlier it was, if you are filing PCT, then only you can file expedite application, otherwise not. But now it is free for everybody. Expedite patent application, you can file early publication, and it is, if you file early publication in Form 9, you deposit the fee, then it will be published within a month. Otherwise, it may take 18 months for. So now you can file early publication so that everything will be expedite. And you can also file expedite examination. That is another form. That way, that is why you have to have some patent agent or patent attorney with you, to whom you can be in contact, and you are always in touch with him or her, so that nothing will be missed out. So expedite examination is filled by Form 18A, and it is the examination will be done within 3 months. So this is very important for if you are going for international patent filing. What are the important steps? If you have some idea, you have done basic research, and you think that it is feasible and the idea is good, you can commercialize it. So go for patent search. You have to search it. Either you can do it by your own, or you can hire some patent agent, some agency who are doing this. So that way you will get to know that the idea is not common, it is a novel idea, and whether it is patentable or not. Otherwise, every step needs some fee. It's a matter of money. So you have to pay money. Before paying, you should be confirmed, you should be ensured that your idea is patentable. That is why patent search is very important. You can do it by yourself, going to Google patents, or you can do it with the help of some patent agent or the company. If the idea is patentable, then you can file either provisional application or complete specification. This is a specific, I have given this, it is filled in Form 2. And the provisional application is, I think, fee is 1,600 only. If you are hiring someone, then he or she will take the money for writing your this specification, provisional specification and complete specification. But if you are doing by your own, it is only 1,600. It is a government fees, whether you hire or not hire. This fee you have to deposit. You have to pay. So it contains the provisional application, contains the title of your invention. The title of innovation or the invention is very important. It should not disclose everything, but it should be little broader, because if you are filing provisional, you may add in something or you can remove something. But in the title will be same. What you have filed in provisional application, the title should not be changed. So you have to be very, very careful while writing the innovation. And one more thing, one very important thing is you have to see what is patentable, what is not patentable. If something is not patentable, so you have, and you want to patent your idea or your innovation, so you can make something as a precursor for that. Or I'll tell you how I molded my application. When I'll give my example, then you will get to know what I am trying to say. So, and it will contain the applicant's name. Applicant may be either you belong to some company or some institute. The applicant should be that institute. You can also be an applicant if your institute or your company doesn't have any patent cell. If patent cell is there, and they are paying for it, so they will be patent. You can be co-patentee, like you can write your name and your institute name. So there are two applicants. You have to name them, write the nationality, the address, and these are there are some forms. If your address is changed, your institute is changed, so there are some forms that are filled for correction of address, correction of adding applicant name. There are some forms. I think it's form 13 or so. My colleague in the next, some time later, she will come and she will give the detailed information. And the third thing is preamble to the description. You have to describe your invention. If you have done preliminary research, then you write in, why you are doing, how you are doing. You have to give the whole information in this. The objectives, the field of innovation, the background of innovation, objectives, and description. Your provisional application contains these information. So as I tell you that you have to be very, very careful what is patent. Otherwise, your fee will be wasted. If your thing is not patentable, then and you are filed the patent, you have filed the patent, so your fee will be otherwise more than fee. You will feel upset that why I filed this. When patent search is important, and you have to know whether what is patentable, what is not patentable. So what is not patentable is the discoveries, the scientific theories, the mathematical method. Like software, you cannot patent. Hardware, you can patent. And some schemes, rules, methods, already established thing, you cannot patent. Some plants, animal variety, you cannot patent. You cannot patent the methods for treatment. Method is you cannot patent. Similarly, you cannot patent, like I'm in nuclear medicine department, so several isotopes cannot be patented. So before filing, I should know whether which isotope is patentable, which is not patentable. So now coming to patent rights. So applicant is the whole soul, has whole soul rights. So the applicant may be the institute, the faculty, the student, anybody can be applicant. But if you belong to an institute and if your institute is paying, so the applicant will be your institute. Then you can write your name, mind it, patent is not a donation. It is not for friendship. Those people who are involved in invention, only names of those people should be there. It's not he or she is my friend and I should write his or her name. No, it's not like that. You can write their name in paper, but not in patent, because it's your property. So it is your intellectual property. It is you spend some time, you applied your intellectual power in this. So it should not be donated like this. So don't include the name of your friends just like that. If they have contributed, then it is very important. You can you give their names. So inventor. What I do if it is a thesis work of my student, so I give first name of my student, then my name, and the people who are also involved in it, I write their name also. But those who are not involved, and if very small contribution, like some experiment help, like if they are doing some experiment, they are there. So it is not. Their brain should be used. So all rights of the patent belong to the applicant. Rights means right to sell, right to license is with the applicant. Applicant, as I told you, it is generally the institute. If institute is not paying, but you have to inform your institute, because it is why it is important, because being like you are in Saraswati Dental College, so because you are in Saraswati Dental College, you are able to do that innovation. You are not doing it at your home, or you are not freelancer. So if it is generated within the premises, because of the patient, because of the work you get that idea, because the type of work you are doing, because type of patients you are dealing with, you got this idea. That's why the institute is the applicant. It should be the applicant. And otherwise you can institute whether I want to patent this. Who will be, are you going to pay for it? Or can I file this patent? Though they give you NOC, no objection, and then you can file patent as an applicant also. But information you have to give. You have to inform your institute. So any logo can be patented through the trademark registration. You can register trademark, you can register logo. I mean, as a trademark, you can protect, you can file logo, you can, if you are designing some logo for even for your department. So as an individual, you cannot file it, but as an institute, your institute can file this for your department. But as an individual faculty, individual student, you cannot file that logo, because that department belongs to your institute. So institute can file, your idea can be filed, and you will be involved in that. But you individually, you cannot file the logo, trademark for logo. So now, if your idea is good, you got the patent. What next? If your idea is good, you have made some product, so you can now thinking of commercializing it. So who can commercialize it and how to commercialize it? If the patent is, you have got the patent, and but your institute is the applicant. So first think otherwise, if you are not commercializing it, how will people know that this is a good idea? Or if you form some enamel that is not that is long lasting, you can file that. But if you got the patent, you have patent with you, but nobody knows it, whether to use it. So how they will use it? Now, just like mobile phone, if you don't have that technology in the market, you cannot use it. So for the welfare of the public and for yourself also, you feel good if your innovation is used by other people. It will get commercial value. You will also feel good. You will get some monetary benefit also. So how to go about it? So it is done by technology transfer or the tech transfer. It is a process of transferring knowledge, research, or the finding into commercialized product. So what you have to do is you have to search for your commercial partner. And though it is very tedious, but you have to do it. And it is not and what is required, that only research that you have done good research, it is not adequate. Specific skill in relation with technology, general awareness and willingness is required, and IP management is the major component which need attention. Like if you have done good research and you think it can be commercialized, it can be commercialized, but it is not sufficient. You have to see the market also, and you have to see your commercial partner, and whether your idea will be used, who are the end users and how many are there. If it is a small population, then people may not be interested in taking your idea and commercializing it. But sometimes, even if the population is small and your product is too good, so you can sell it for big. So you have to keep these things in your mind. So what is the importance of technology transfer? So it provides a platform to share your product, your innovation. It also helps to protect your intellectual property, and you can also commercialize if you have not got patent, if you have applied, if you not even applied. So first thing is you should apply, or you should file the patent. And even if it is not, if it is only filed and till the time you want to commercialize, it is not granted. So you have to sign a non-disclosure agreement or non-disclosure agreement, so that nobody can misuse your information, your innovation. So this agreement is with you. It gives recognition to your research and also your commercial partner, and it will help to create revenue for researchers like you and me. It will enhance economic development for both. It is for your institute, for your nation, and it is also beneficial for the society. It will save, like for the people like us who are working in healthcare, we can save the people's life. We can save their quality of life actually. And it is even if just like that, you just for the example, earlier people are wearing dentures, but now they have implants. If the people have not discovered that these dental implants can be implanted, so I think it is technical advancement, and it will give employment for manufacturing. So it has lot of benefits. It is not for you, for public also, for patients, for society, for the nation. So go and file the patent, commercialize it, and be happy. So what are the steps? If you have, it is step by step. That first, invention disclosure. An invention disclosure form is to be submitted by the researcher for providing detailed and necessary information. And this disclosure is evaluated and meeting itself with the concerned person. This is for commercialization. They will evaluate, and evaluation is done based on the market assessment that I have already told you, that how many people, who are the end user, what is the market value, and then whether you have patented your rights, your innovation or not, or if prior art means whatever is already present, that is prior art. Prior art search is done or not. And this analysis, these are done, the evaluation for your innovation, then patent filing, you already know now, and then assessment and marketing. Assessment is done after filing the patent, or if you have not done, then you can file NDA or MNDA, mutual agreement, mutual non-disclosure agreement. So you can give in writing that this product, the company cannot make this product for anybody else, so that it is not copied. It is always better if you have patent, then you need not to worry about it, because it is now in the public domain. Everybody knows that this is your patent. You have your patent certificate, your patent number, published patent. So otherwise, then you need not to worry about it. If it is not done, then it is mandatory to sign a mutual agreement or non-disclosure agreement. Then once the company people are ready, okay, then you can license it. License means you can give the authority of your patent to commercial person, give this authority to a person. You give license to one person, or you can give to several people. If you one person, then it is exclusive licensing. If you are giving to several people, then it is non-exclusive licensing. So both ways you can go. So and you can license for limited period, like you are renting it for 5 years, for 2 years. Then you can say, then I'll think about after 2 years I will reevaluate and then give another license to you, so you can sell in higher price, so you will get more money. Because in the initial stage you may not be able to assess the outcome of your product, how the response on your product. So you can license for even shorter period of time. So, hello. Okay. So the technology readiness level includes 10 steps. One is idea. Actually, these are 4 steps. One is idea. Then idea is you get an idea, you did basic research, you develop your technology, you validated it. This is called the idea. And then you prepare a prototype. Prototype is a model of your innovation. So it is ready for to see the people that it is doable, it is useful, it can be commercialized. And then once you prepare your protocol, you can validate, like you have developed some implant, the material is so good, so you have to validate it. You will validate by yourself in your department after getting ethical clearance from your institute, and then you can collaborate with your colleagues in different organizations. So that way you can, just like multi-center trial. So then you will get to know that it will be recognized by those people also. So you will get more confidence, and it will be the validation will be more, will attract the company people also. So you can say that not even myself, my institute has used it, my department has used it, but and it is also used by AIMS, Tata, Falana, Dimkana, whatever. You can say then 10 institute have used it, and it is giving good results. So, and then you can ask the company people, you can give license to the company, you can you can give, there are some mediators also who take your patent and give for that is a platform from where the commercial the company people see those the profile of that company, the license, these companies, these mediator companies, they publish your idea on their website. So the company people can pick that, and they can contact you for commercialization. Commercialization is they will scale up, and they will prepare in bulk, and they will distribute to other institute also with your permission only. They may take lump sum money from you and do rest of the thing, or you can offer, and they can offer you some 5% or 2% or whatever percent, 10%, 20%, 50% of their the what you call, whatever money they are generating, they'll give 50% of that. These are different types of commercialization process. It is with you and the company people. And I have not done any commercialization till now, but I am planning to. You can make your own startup, but you have to take permission from your institute. Private institute give permission for startups, but the government institute like my institute, it will never give permission for startup. So I have to license it, but I have not a very good idea for commercializing. So, but I'm telling you that you can do it. So if you have developed your innovation, your idea in technology ready level, and you have market also, then you can commercialize it. So any question about for this, then I'll move to my experience, my journey. Any question?
Ma'am, this is Arvind Tripathi. And
Yes.
I have two questions before we can
Right.
take questions from others.
Yes.
Well, I have been a researcher of a low profile for a long time now, and I have seen how the research world moves. You have done good quality research, and you've had patents. I have two questions. The first question is that all of us work in some institution. We are affiliated with some institution or the other. Like you are affiliated with Postgraduate Institute of Medical Education and Research, Chandigarh, and you conduct research which is patented. To what extent does the affiliating institution have a right on your patent? And do they obviously you're going to mention your address in the as a primary applicant? To what extent does the institute have a right on your patent, and till what time can they actually exercise that right after the patent has been granted?
Okay, very good question. Because it is your intellect you have developed, but because being in that institute you are doing this research, so institute has, I mean, mostly the 30% right they have. They will not give money for filing for getting patent, but whenever you are going for commercialization, they will claim their share. And without their permission, you cannot do anything. You cannot commercialize it. So if your institute has some patent cell, they may have some policy. It's individual institute, but it is generally 30% share they will get. If you are, say, if you are licensing in 100 rupees, they will get 30 rupees and you will get 70 rupees. And 70 rupees will be distributed in within your inventors, and it's your individual agreement whether they will 50, 30, 20, whatever percentage you want, because whose mind is mainly involved, they will get more. Times
Okay.
if the people are just doing the work, they may, yeah.
My next question is probably a little more interesting, and it is a little investigative also. You have done a lot of research, and you and I live in an era where, in my opinion, there are two kinds of researchers. One kind is who actually puts his mind, his effort, devotes himself to research, comes out with original ideas, implements them, publishes them, and it is gratifying enough to find that your idea actually found. Hello. Hello. Hello.
Your voice is breaking. Yes, now it is clear. Yeah.
There are two kinds of researchers in today's world. The first, obviously, are those who are toiling very hard to implement original ideas, researching them, then coming to a result, trying to publish them, eventually getting success in publishing, and by that way getting the approval of the international scientific community. It is very, very gratifying for them to this extent. Right. There is another group of researchers who are probably equally successful, who are trying to find ways and means to get themselves included in researches in which they have nothing to do. It is not even their field, even to the extent of going into Cochrane reviews. I mean, it is so very shocking for the first group to find out that people who have no relationship with a particular research, by some hook or crook, prominently monetary means, they go to the primary applicant and they get their name published. Unfortunately, to my mind, as far as I know, there is no ombudsman, there is no research policing of any kind in our country. If you report plagiarism, if you report such incidents of people putting in their names in researches and patents and other intellectual property rights in which they have primarily no claim, there will be no policing, there will be no examination. Right. So it just actually, after so many years, I am already in the twilight of my career. I will retire in a few years. I feel that, is it really worthwhile And what kind of a precedent are we leaving for the young researchers who are true blue researchers, who want to do good work, who want to do original work, when they are pitted against such people who do nothing? They just spend money and get their name printed somewhere or the other. Because when the annual assessment is done, the original researcher is put at par or maybe below such bogus researchers, I would call them. So it is very, very
Right.
unfortunate. And you see the scientific community in our country is shrinking. That is why people are wanting to go abroad, and they want to, the true blue researchers don't want to stay in the country. And the scientific community of India is suffering. Every field. See, when we talk about nuclear energy, when we talk about atomic energy, we used to have stalwarts earlier. People like Homi Bhabha, people like Vikram Sarabhai, people like M.G.
Yes.
Kemenon, people
Yes.
like APJ
Because
Abdul
of
Kalam.
them,
Where
India
is
is
the where is the succession? People are not interested in science, madam. People are interested in doing MBA. People are interested in doing startups. People are interested in running NGOs. Most of which, unfortunately, are bogus, because everybody wants money. Fine, money is a good thing to earn, but if scientific contribution, because we have very bright minds in this country, let me tell you that I am so very happy and so very proud
Yes.
of the scientific content of India. We have contributed to original scientific research internationally from a long time, and we have been acknowledged even abroad. There are several scientists who are doing so well in the United States and the United Kingdom and Australia and other countries. So it is really pathetic that their true mettle is not recognized in our own country, and they are frustrated. And it is not probably exaggerating to say that they flee the Indian nation and they go and settle abroad. And that again is a national loss. So don't you think
I
that at
agree with you.
some point of time, we need to have some kind of a very strict policing on all this? Plagiarism, inclusion of names in patents in which people...
But who? But who will do it? Who will do it?
Exactly, ma'am. That is
Dr. Tripathi.
Yes, sir. Yes,
I
sir.
will interrupt you because I think we are slightly diverting from the topic. So it is more of ethical and moral and constraints which one should have in the publication. For that, we can have a separate discussion and separate webinar, I think. Let's
Since we were talking about individual property rights, I was just wanting to allude
I know.
what is individual property right in today's times when people are stealing away your right.
So I think let's continue with the part for which we are today. So we'll have some discussion afterwards in some other session for this. Okay, ma'am. Professor Shukla, you can continue, please. If you want to add to something on what Dr. Tripathi said, you are you're welcome to say.
I can say that people are there, but you keep doing good work, keep going. You can't help it. You can't help them to be ethical. Be ethical and teach your student to be ethical, but you don't have any control on others.
That's right. So please, any other question from anyone? I think, Professor Jaya, you can continue with your journey now.
Yeah.
Okay. Yeah. Okay. One more thing I think I forgot to tell about patenting. But I forgot one thing. And during the questions, I remember that, but again, I forgot. Okay. Coming to my journey. Similarly, I have done something, work, which was when I was in my professors asked me to go for patenting. That time I had no idea how to go about it. I was little hesitant, and I think it required a lot of money. More than money, I think it is my callousness, whatever. But when I saw, and I was also thinking that if I will patent it, nobody can use it. But it is not like that. Now I understood that it is not like that. I can patent, and it can be used for a lot of people. Otherwise, if I transfer my technology, I will commercialize it. Then that is how the things moves. The mobile phone may not be, if it is not commercialized, we may not use it. This computer, if it is not been commercialized, we could not use it today. So it is. And similarly, I thought about our Ayurveda charyas. They know a lot of medicines and lot of herbal things, but they have not shared with anybody. And they die with their own idea, their knowledge, and they have not shared with anybody. You may patent it or may not patent it, but you have to share it with like-minded people so that it is propagated and things moves on. So I started my patent journey when I saw that the hepatocellular carcinoma, which is a lethal malignancy, and the treatment for this was very, very costly. The people are using, because I am in nuclear medicine, so I know what is done in nuclear medicine. That I only know that. I am not aware of all other things, but in nuclear medicine, because I was in this field, so I that it is the therapy which are being used cost 10,000, 10 lakhs for single therapy. So I was very shocked, and I thought that people like me, or even low medium class cannot afford it. So I thought that if I can make something for this, it will be wonderful. So I started working on this. As you all, I think all are knowing that this hepatocellular carcinoma is a primary liver cancer, and the livers get supply from the from the portal vein, but the tumor gets most of its supply from the hepatic artery. So what the commercial, what is Y90 micros were commercially available, and they are delivering this with a catheter to the tumor bed. If it is a small tumor, they super selectively deliver it. And if it is the whole lobe is involved, they deliver to either right hepatic artery or the left hepatic artery. So that way they were doing this therapy. And during my PhD, I have developed some microspheres for knee joint radiation synovectomy. So I thought if I can prepare little bigger size, that may work in this also. So I worked on it. I talked about it with my professors, with my colleagues in different departments, because radiology people were doing this and the patients are coming from hepatology. So we talked about it, and then I asked them to give few patients in which they have already planned for. There are two types of therapies: transarterial chemotherapy and transarterial radiation therapy. Tear and TACE, chemoembolization and radioembolization. So I asked them, then if you give me 5 patients who are planned for chemoembolization, I'll get ethical clearance from the institute. But first, I should know whether you will give me those patients or not. So I got permission from my institute, and they are ready, because I was from AIIMS, and somehow God was great, and they believed in me, and they allowed me to give very few millicuries, like 3 to 5 millicurie I have asked them, and the dose is more, 100 to 200 millicuries. But I asked them to allow me to give only 3 to 5 millicuries, and then go for therapy, whatever they have planned, chemoembolization. And then once I inserted these microspheres with the same catheter, then I imaged those patients in my department. I did some serial imaging and show them that these are residing in the tumor. These are not leaching from the tumor. So they were impressed, and that is how I developed. Then I thought of patenting it. Then I filed a patent with rhenium radio label microspheres. And once I filed it, and within a year, I filed complete specification. But somehow, from the patent office, it went to the Department of Atomic Energy because it was labeled with radioactive material. And they straightforward rejected my patent, and it was lying for 1 year to patent office, and I did not get any information. So then I keep on asking what happened to my patent, what happened to that. So then I get to know that my patent was rejected. It was rejected, and then I met some people in some, I think it was some patent attorney or someone I met, and he said, let me check whether your isotope is patentable or not. Then he checked it, and it was not in the list of not patentable item. So I filed a review petition to the department, to IPO, and then to Ministry of Health, and even to Prime Minister. I forwarded that letter to everybody, Health Secretary, Health Minister, everybody to whom I think is relevant. And then I call from file it, please file it. It was I filed it in 2015, and in 2007 was over. I was, if in the normal routine, I was not, it will be abandoned, but it was not my fault because they have rejected the patentable item. And they said, because it is carrying a radioactive material, you cannot patent it. And after filing my review, so always fight for your right. I thought it is no will be no in any case, but it may be yes in 0.001%. So that means it is, if it is yes, then it will be 100% for me. So I filed that review petition. I fought for it, and ultimately I got this patent in 2020. So this is my innovation. I prepared microspheres, and the microsphere which were commercially available were Y90, and the radio label product is the available material was ready to use. You need not to do anything, just get it and inject in the patient. So that they were charging and some money. In government institute, it was 10 lakhs, and in private, I don't know what amount they were charging. So rhenium is another isotope which is used for therapy, and it is also used for it also have a imageable radiation that can be imaged under camera. So for this type of therapy, what is done is, before giving therapy, because it is beta emitter and it will kill the cell. So what they do is they do pre-therapy calibration, pre-therapy dosimetry, you can say. So they were doing pre-therapy dosimetry with a small dose. Like I said, I asked them to do small dose, which is not harmful, which will not be anyway harmful. So they were doing that pre-therapy dosimetry with another isotope, and they were using transarterial catheter, which are very costly. So they are doing procedure twice, one for assessing whether it is the patient is treatable or it is not, it will not harm the patient, because the hepatocellular carcinoma is a nasty tumor. It form collaterals with nearby organs, especially to the lung. So to assess the lung toxicity, they do pre-therapy dosimetry with another isotope, another pharmaceutical. So, and because this rhenium is having imageable as well therapeutic radiation, so what my innovation did is two things in single go. We inject 3 to 5 millicurie for dosimetry purpose, and if it is suitable, it is not harming lung, then immediately after that, we give therapy. So it is beneficial for the patient because it is giving only one transarterial therapy, and it is saving the money because procedure is done twice. So it is discomfort for the patient and double the money, the cost, because the costliest thing is transarterial catheter, and 2 catheters are used in single procedure. So procedure is twice, procedure was done twice, and cost is very high. So I did this with, and the microsphere which I have developed. First, I have developed rhenium microspheres. Okay. So first I have done radio labeled rhenium microparticle. And then during this period when my patent was rejected, I thought of making it dry kit so that microspheres are available. It can be radio labeled at the center, at the hospital center in the radiopharmacy lab. So I have developed another product, and that is I got patent for rhenium labeled microsphere. Then I also prepared these microsphere as a cold kit. I also developed a protocol which is very of 30 minutes only, and it can be labeled with diagnostic as well as therapeutic radiopharmaceutical radionuclide. So we do this diagnostic or the dosimetry dosimetry imaging first, and then and you can see that it is residing in the tumor only. High amount of activity is residing, similar to Y90. So we have done, till now we have done 50 patients, and the most important thing is these microspheres are used for other purposes also. We are doing therapy for the basal cell carcinoma by making the radioactive patches and applying it on the patch for only 4 hours. That is single treatment, and it delivers about 100 gray to the keloid or to the basal cell carcinoma, and people are benefited. So we have done more than 100 therapies for basal keloids and 50 patients for hepatocellular carcinoma or metastatic liver only therapy, if the metastasis in the liver only. So we have treated few images for basal cell carcinoma, and this is basal cell carcinoma, and these are for keloids. Another molecule, how much time I have?
Ma'am, we are just, we should close it now.
Okay.
Yeah.
How many? 5 minutes? This is my last patent,
Yeah,
actually.
Yeah.
So this is another very interesting product or the innovation. You know that pituitary is very small gland, but a master gland. And pituitary adenoma, microadenomas are not visible sometimes in MRI or CT. So my colleague, it was not my idea, it was my colleague's idea. She is endocrinologist, and she said, can you label this molecule to see pituitary microadenoma, which is hard to see, and if it is not visible, people either remove adrenals or remove the whole pituitary. So I developed this idea. Idea was her, but I materialized her idea into reality. So I developed this peptide and labeled it with PET agent, so that this pituitary tumor, it can be highlighted, and the surgeons get to know it help in navigation during surgery. It will delineate the tumor within the pituitary and help in delineation during surgery. So now they are not doing surgery without this scan. So we have developed it. Even we get referrals from AIMS. AIMS patient come to us and we do this. Now I want to commercialize it. Whether I will be able to do it or not. So I got patent for this also. Hearing is done, but it is in Department of Atomic Energy because it will be used only after radio labeling. So it is again in the DAE and lying for 1.5 years in DAE only. They are not giving any reply to whether it is patentable or not. Though I know because it is this isotope is also not in the list of not patentable isotopes. And my 6 more patents are published. So I will suggest the important thing to remember, don't publish. If you get an idea, you have done some research, don't publish. First file it. Even if you file today, you can publish tomorrow. You prepare your manuscript ready, just file it and publish next day. Otherwise, what will happen if you publish it, you will not able to patent it, even if it is your publication, then also. Or even if you have presented in some conference and it is in the proceeding or it is in the internet or the public domain, you are not able to patent it. So some other innovations, okay. For that example, because it is my students' work, we have radio-labeled tamoxifen for imaging and therapy. So the imaging part she completed first and then presented in a conference, and it was published in international journal in conference proceeding. And then when we applied for in search, we have given to a patent attorney to do search, and she said it cannot be patented because see the publication. So it was our own publication, but we were not allowed because it was in the public domain. So this is my team who is doing all the research work for me. And I'm very grateful to all these youngsters and my department. I'm really indebted. They have given me full freedom to do research and they are cooperating with me. They give, and whatever I do, they are ready for their patient. Yes, I get ethical clearance from my institute. Otherwise, I don't practice any unethical thing, but still they believe in me. That is why they are allowing me to inject the drugs for imaging patients after getting ethical clearance. So I am very grateful to all of them, and I am very grateful to you also bearing me. I thought I will not be able to spend 1.5 hours on patent, but somehow I managed.
Thank you, ma'am. Thank you, ma'am, for the wonderful presentation. Now I invite our principal, sir, Dr. Dubey. Sir.
Yeah, Professor Jaya, this was indeed a webinar or whatever I say, lecture, or it was a information, very wide, widely given information to all of us. Most of us are not at all aware about these patents, copyrights, trademarks, what is the difference between these things. So you have really presented this very complex subject for all of us in such a detailed, and also the fine intricacies also they have been explained by you so well. I'm really impressed, and many things I have also understood today. And one thing I really appreciate, you explained about your experiences, the struggle which you did. But I think all that struggle which you did really motivates everyone who knows about it. I'm really motivated with that. And patents, as you rightly said, I just got to understand one very important thing from your talk, that the patents are something which teach you, the others, because if you don't get the things patented, people will not know, world will not know that the research can be done in this direction also. So they are actually the lighthouses. So it is not, you are not keeping, by doing the patents, you are not keeping the things up to you, but actually you are showcasing the ideas to everybody else in the world, and that is how the world and the society grows. So I think it's a very excellent idea. One should get the patents to show the way to the others, and the that is the way we will grow in the society, and we get motivated, especially the young minds who have a lot of energy and a lot of ideas. They can get motivated, but the age is no bar for all these things, I know, for the ideas and for the growth. So it's really, it was very indeed a good feast for all of us. And these fine things about the how to file the patents, when to file the patents, what can be the objections, and how the institutions can be collaborated in this, what should be the addresses mentioned in this. So really, thank you very much for giving such wonderful informations to all of us. And some questions which were asked by Dr. Tripathi, they were very, very valid. But for a good researcher, if there is some, some theft or some plagiarism, then it really hurts. So he also raised a very valid point, and we can have some, wide discussion on this point also at some point of time. So thank you, ma'am, very much. And on behalf of Saraswati Dental College and our management, I pay my thanks to you and for your presentation. And as a appreciation, we are just presenting you with this certificate online. I wish we could have met offline and listen to you face to face. But anyhow, in future, yes, we will get some time for this. So thank you very much. Kindly accept this certificate of appreciation.
Thank you, sir. Thank you, sir.
Thank you so much.
There are few questions in the chat box, but you can always mail me. My email address is shuklajay@gmail.com. Otherwise, also my colleague in some other lectures, she will give you the broad overview, which I may not be knowing. She knows better because she is patent agent also. So she will give you the broad overview on that. And if any question, you can always send me on my email, shuklajay@gmail.com. Thank you, sir.
Thank you. Thank you, ma'am. Thank you. Okay, Dr. Benz, you can please take over.